Greetings. My name is Walter Wilson, and I am a lawyer practicing in Houston, Texas, and I have been practicing for over 50 years. I started practice as a forensic medical officer with the United States Air Force, and I was stationed at the United States Air Force's School of Healthcare Sciences. And as a forensic medical officer, I taught at the School of Healthcare Sciences. I taught at Northwestern University for the dental advanced and expanded dental assistance program. And basically, I then got out of the United States Air Force and went to Houston and joined the faculty of the University of Texas Dental Branch and the University of Houston Optometry School, where I taught practice management. And one of the things I observed was that virtually every doctor who was incorporated, when asked two questions. The first question is, why did you incorporate? I don't know. And why did you make an S election? I don't know. My CPA told me to do it. And I said, well, would you be concerned if I told you that your professional association or your professional corporation, if a judgment were rendered against you, a judgment creditor could seize that entity through a licensed receiver and take everything that is in it away from you? That could be accounts receivables, that could be equipment, that could be credentialing with various payors, it could be a commercial lease. But if you were to convert that PA or PC into a professional limited liability company on most state laws, and this is governed by state law, you can eliminate the exposure. And your single biggest cash cow and value generator is your practice. So one of the things in Texas that we did was in September of 2009, Texas adopted the professional limited liability company conversion law and suggested that if a doctor practiced medicine or dentistry as a PA or a PC, that they could, by converting the PA or PC into a PLLC, a professional limited liability company, the exposure to a receiver from a judgment creditor would be eliminated. Our firm had almost 700 PAs and PCs on the books on May of 2009. In September, when the statute became effective, we had zero, not one. The IRS considers it only a name change, so the federal ID number stays the same, which means the credentialing stays the same. Your tax structure as an S Corp, which is probably what you are, would stay the same. And so there's no interruption in payments from payors. But the enormous amount of protection is that the ability for a judgment creditor to appoint a receiver licensed as a physician or dentist to step into your shoes is eliminated in most state statutes. So the one thing I would suggest that you take out of this episode or this video today is call your lawyer in your state and say, I listened to this asset protection video for doctors who are practicing as PAs or PCs, and they suggested that I call you to see if our state recognizes PLLCs, professional limited liability companies, and whether the remedy of a judgment creditor to have a court-appointed licensed receiver has been eliminated, which in most cases the states have eliminated it. This protects the cash cow, the practice that you have spent decades building, from the eventuality, if there is a judgment rendered against you, that it could affect your practice. It is gone. So I encourage you to call your lawyer, and I'll look forward to talking to you again.